Hello viewers, I am Dr. Anil Kumar Sharma, criminal defense legal practitioner, speaking and sharing with you on topics of criminal justice system, CRPC, evolution of constitution and the FIR. By virtue of Article 245 and 246 to the constitution, enumerated in the concurrent list of the 7th schedule out of the 12th schedule of the constitution, also called the Twilight Zone, the FIR, the sine qua non of the legal system, the most debatable, discussed and disputed or deliberated element of the criminal justice system. And the endeavor will be to simplify as well as streamline it at the outset. To put it in a lighter vein, I would like to say that I may not confine to my subject, but I will justify to be resonant with the code of professional ethics and standards along with the BCI rules and guidelines. Constitution is a grand norm, basic norm. Every country has its constitution, different constitutions, but goal is the same, welfare of its people. In a lighter vein, I would like to say that I may not confine to my subject, but I will justify it to be resonant with the code of professional ethics and standards along with the BCI's rules and guidelines. Constitution is a document which survives for centuries. It is a dynamic and evolving document, flexible to meet the needs of present times. Constitution of India having constitutional supremacy rather than parliamentary supremacy. Aristotle, the great ancient Greece philosopher, raised the question whether it is better to be ruled by the best of leader or by the best of laws. Ultimately, he concluded in his work, Politics, that government elected by the people is the best form of government. Separation of power, in which he divided three entities of the state: the legislative, the judicial, and the executive. These three entities are separate to avoid the abuse of power. He further added that it would be a tyranny or oppression under the shield of law or in the name of justice. Therefore, the Latin term, the salus populi suprema lex esto, meaning thereby welfare of the people, including public health, should be the main aim and objective of the Constitution. Even the philosophy of great French scholar Montesquieu influenced the constitutions of US and England. He exhorted the separation of powers. Montesquieu said that the society is the union of men and not the men in themselves. The theory of Kelsen, where he propounded the constitution as grand norm, is better than the command theory of Austin. Hence, different constitutions, different countries, ultimate aim and object is welfare of people. What William Shakespeare rightly said, what's in a name? Whereas Alfred Tennyson said, old order changed, yielding to new one. Now our triple criminal laws are in the offing, just round the corner, to get people aware of that justice is the fundamental right. To access justice is reach of everyone. As per our FIR, is the most debatable, discussed and disputed sine qua non of legal system. But potential of India in terms of its rich heritage, culture, custom, traditions, rituals are unparalleled. This is unity in diversity, and it is the strength of India. Down the memory lane, our pre-ancient period, also called Golden Sparrow, followed by Sultanate, the Mughal period, during which the term Vakil was coined, followed by modern period, 1600 onwards. During 1857, the revolt and the rebellion, transfer of power took place from company to crown. Governor General changed to Viceroy. And a new police law enacted in 1861. The act was mainly to suppress the rising voice of the people. It was not a welfare act. Then followed our constitution, drafting of the constitution. Dr. D.R. Rao, the constitutional advisor to the Constitutional Assembly, later on he was the president of the General Assembly, UN General Assembly, and also the Justice of International Court of Justice in The Hague, Netherlands. Dr. Ambedkar said, the credit of drafting of constitution belongs not to me, but partly to Dr. D.R. Rao. The constitutional advisor to the Constitutional Assembly. In his speech on 25th of November 1946. It was D.R. Rao who said that three things are common in every constitution, first being the ex post facto law, second, right against double jeopardy, third, the right against self-incrimination. The first ex post facto is dealt in Article 30. Retrospective and prospective laws. Those laws which were not in line with the fundamental rights, that part declared unconstitutional. And the prospective laws and retrospective laws marked the needs of the time, and only those portions were declared unconstitutional. A doctrine of eclipse or doctrine of severability was followed, so that fundamental rights of the individual could not affect. Double jeopardy, second one, is no one should be punished twice, is also under section 300 CRPC. And the third one, right against self-incrimination, in Article 20 subsection 3, Article 21, 22 of the Constitution. Protects the rights of accused. Similarly, in the Constitution of US, the Fifth Amendment right is the most important amendment out of the 27th amendments. Is followed as per the needs of the people. In US, 95% cases are resolved on the basis of pre-bargaining. Fifth Amendment right, and only 5% cases face trial. In CRPC Chapter 21A, is devoted to pre-bargaining. Pre-bargaining was introduced after 153rd Justice Malimat Committee report. In the US, the famous cases like Marbury versus Madison, 1801, where the judicial review came to exist. There was some rivalry between the outgoing president Madison and the incoming president Thomas Jefferson. President Madison, before demitting office, appointed some appellate court judges. Marbury could not get appointed. He appealed. To the Senate. Senate approved, subject to the condition that Madison, the Secretary of State. Two important cases in the US constitutional history. First being Marbury versus Madison, and second one Miranda versus Arizona. Marbury versus Madison, 1801. There was some sort of rivalry between the president outgoing John Addison, and Thomas Jefferson. John Addison appointed some appellate court judges before demitting office, and one Marbury could not get his appointment. He appealed to get appointment, but it was dismissed by the Secretary of State, and he filed writ of mandamus in the Supreme Court of US. John Marshall, the Chief Justice, allowed his writ but did issue it, and called Section 13 of the Act unconstitutional. Thereby, he established the doctrine of judicial review. And judicial review followed throughout the world in their constitutions. The second one, Miranda versus Arizona, 1966. Miranda was arrested under charges of rape and abduction, forcibly made to sign statements under detention, without engaging an advocate. And the court declared its judgment in favor of Miranda because his rights were curbed. He could not defend himself. Ultimately, arbitrary arrest were condemned and set the guidelines how to make arrest. In India, Chapter 5 talks about how to make arrest. In CRPC, Section 41, arrest by police in an cognizable offense, (41A) notice to appear before police, (41B) procedure of police, how to make arrest, (41C) making PCR, (41D) engaging of lawyer or services, by the lawyer to the person accused. 42 talks about arrest the person when he don't gives his name, address. 43 any person can arrest. 44 magistrate can arrest. 45 no defense personnel can be arrested. 46 how arrest is made. 47 search of the place where arrest is made. 48 beyond jurisdiction police can arrest. 49 no force is to be used. 50 tell the accused right to bail. 51 search of the person. 51A section 51 search of person. 52 search of offensive weapon. 53 medical examination of the accused person on the request of the IO. 51(3)A medical examination of the rape accused without his consent. 54 to tell about his rights. 55 order to subordinate, how to make arrest. 55A health and welfare of the accused. 56 brought the accused before the police station or the magistrate. 57 within 24 hours to be brought before magistrate. 58 if accused try to escape. 59 and 60 or 61A as per the arrest made as per the rules of CRPC. Before drafting constitution, our constitutional advisor Dr. D.R. Rao visited US to meet Associate Justice Felix Frankfurter, who was legal advisor to President Thomas Wilson in Paris Peace Conference 1919 near Versailles. He advised Dr. D.R. Rao that not to use due process of law, though this term has been in the US Constitution itself. So on his advice, in the Article 21st of the Constitution of India, right to life and liberty, according to the procedure established by law, was inculcated. instead of due process of law. Though in the Article 14 of the Constitution, equality before law or equal protection of law is there. Equality before law is the English Constitution, and equality before law is the US Constitution. In rule of law, as sounded by A.C. Dicey in his book The Constitution of England, that under equality before law, even the Prime Minister and the common man are equal. Because of supremacy of the law. And the same is followed in the Indian Constitution. Indian Constitution faced some unprecedented decisions during the first quarter of its existence. Within a 1 month of the adoption of the Constitution, preventive detention bill was introduced by Sardar Vallabhbhai Patel, passed in 1950 to 1968. It was to keep peace and tranquility in the country against the situation prevailing at that time. Even UAPA, Unlawful Activities Prevention Act 1967, was passed. And preventive detention though not in operation, but its provisions are laid down in Section 151 CRPC. In 1951, Shankari Prasad versus Union of India, fundamental rights were violated, and Parliament amendment was given supremacy. The Universal Declaration of Fundamental Rights, UDHR 1948, are the most followed rights or documented rights globally. Our former ambassador Abid Hussain the UDHR, the Universal Declaration of Human Rights 1948 document, is the most documented, translated document in the world, and it is the most accepted document, a milestone document globally. Our former ambassador Abid Hussain of USA, our former ambassador to USA Abid Hussain was a rapporteur for 6 years consecutively in the our former ambassador to US Abid Hussain, to whom I did meet him, was 6 times rapporteur in the fundamental universal. Our former ambassador Abid Hussain, our former ambassador to US Abid Hussain, to whom I did meet him, was 6 times rapporteur in the UDHR Council. His task is to study human rights violation in countries, find solutions, and report to the Council. The aim is that human rights are not violated and they are to be treated at par with their counterparts. In our criminal justice system, the protection of human rights is of utmost importance. Our criminal justice system is based on pro accused. A person is deemed innocent until proven guilty in the court of law, and the accused is granted all defenses to defend himself. And on the other hand, the benefit of doubt goes to the accused in case the prosecution authorities fail to garner sufficient evidence in support of accusation to declare accused guilt. Regarding FIR, I believe it is the best option not to approach or rush to the police station. Take time, settle down, talk between the parties in order to resolve some unseemingly bottlenecks. There are number of ways outside the litigation. One can take the advantage of ADR, alternative dispute resolution, arbitration and conciliation centers established 1978 Act, and which allowed lok adalats, in civil cases. Not serious one can be resolved in the lok adalats. Statutory bodies, decision is final, no further appeal. Even now public utilities have been added since 2002. People can approach to seek solutions pertaining to public utilities also. Salsa is there now. Indigenous people are free to access Legal Services Authority to engage lawyers without paying fees. People having 1 lakh can avail the services of lawyer under the National Legal Services Committees in High Courts and in Supreme Court up to rupees 5 lakh. If no resolution is seen or coming through, only then one should approach or knock at the door of the courts. Police is always reluctant to register FIR. Main reason being they want their jurisdiction free of crime. Rising crime will naturally bring them bring inefficiency in their services. Yes, if your information or commission of offense is cognizance, serious one, then it is the duty of the police to register FIR. Suppose they don't lodge your FIR, what options are there? First, convince them. If not, go to higher authorities under section 36 CRPC, file informatory petition. Again, no outcome appears. Endorse copy to State Human Rights Commission, National Human Rights Commission, CM cell of the state, police website. Again, these endorsement do not bring any result, then approach court through 156 subsection 3. Options are there. One can go for FIR or one can go for complaint under 200. Under FIR, some people want complaint, some don't believe in police, some people want FIR to be registered. Under 156(3), magistrate order police to register FIR. Investigate a pre-cognizance stage. As was followed in Devrali Lakshmi Narayan versus Lakshmi Narayan Reddy, 1996, judgment authored by Justice S.R. Sarkaria, that police is to register FIR when magistrate order under 156(3) in a pre-cognizance stage. In Sakri Basu versus State of UP 2005, 6, 7, 8 and 2005, so it was held that magistrate has power to order proper investigation. because it is clear under Article 50 the powers of judiciary and executives. Judiciary can't interfere in the executive power. Magistrate can order proper or monitor the investigation conducted by the IO, but he can't interfere how the IO is conducting the investigation. Before 2005, people generally avail 482 in High Court to register FIR when police deny the same. But after the Sakri Basu case, it was held that magistrate has power itself under 156(3). Then why go to High Court? It was unutilized at that time up to 2005. Only after 2005 it was made available that a victim or a complainant can register his FIR through 156(3). And further investigation 156(8). Police has power to conduct further investigation. Similarly, if magistrate can order investigation under 156(3), then he has also power under 156(8) for further investigation. Pre-cognizance and after cognizance, after 23 years, it was settled in 2019 in Vinubhai Haribhai versus State of Gujarat that magistrate can order investigation in post-cognizance stage before the starting of the trial. The landmark judgment was delivered by the bench comprises of Justice R.F. Nariman, Justice Suryakant, Justice V. Ramaswamy Subramaniam. Before it, magistrate was not utilizing its power to order investigation in a post-cognizance stage. The judgment delivered by Justice S.R. Sarkaria was equally good. In the context of that case, but the power of magistrate to order investigation in a post-cognizance stage before the commencement of the trial was a landmark judgment. In complaint case, magistrate can also order for investigation, but this investigation is limited to some particular points. Under 200, magistrate examine the complainant and witnesses, record their statements, undersigned. Cognizance is taken under 191A, and if it is a police report, or FIR, under FIR, cognizance is taken under 191B, and magistrate has power to take cognizance suo motu under 191C. One thing is clear, that magistrate can take cognizance suo motu. Suppose, though this provision is used very rarely by magistrate, under 191C, suppose a magistrate has rivalry with any person. FIR is lodged against that person under 191C. At the same time, the person has option under 191 to transfer his case to another magistrate, or 192 court may commit case to another magistrate. So in this way, CRPC provision have a balance equation. In the pre-cognizance stage, magistrate can order investigation 2H section CRPC. In the case of Bhagwant Singh versus Commissioner of Police, 1985, 3 judges bench, judgment authored by CJI P.N. Bhagwati, that magistrate has power to order investigation in a pre-cognizance stage under 156(3). In 2009, Justice Justice Altamash Kabir and Justice Joseph, in the case of Rita Negi versus State of West Bengal, ordered that magistrate under 156(3) can't order investigation suo motu. In 2014, in Vinay Tyagi versus Irshad Ali, Justice Swatantra Kumar and Justice A.K. Patnaik ruled the previous judgment delivered by Justice Altamash Kabir and Justice Joseph per in curiam. In 2017, Justice Deepak in 2017, Justice Deepak Mishra and Justice Amita Roy in the case of Amrit Bhai Amrit Bhai Shambhu Bhai versus Suman Bhai Kanti Bhai Patel observed that magistrate can order investigation in a precognizant stage. Therefore, the judgment delivered by Justice P.N. Bhagwati, a 3-judge bench, still prevail. When after investigation, under 156, police now this stage is after registering FIR under 154 subsection 1, 155 NCR, and the complainant with the NCR is sent to the magistrate to register complaint. 156, power of police to conduct investigation in cognizable cases. 157, report to magistrate of occurrence report. 158, through report through subordinate officer. 159, if police finds no evidence, it file closure report. And it is magistrate's discretion under 159 either to accept it or inquire himself or through his subordinate, or either to entertain as complaint. Magistrate can also order for further investigation, and under 160, police send notice to witnesses. It is to be noted that police can never send summons. Summons are only be served through the court of law. Under 161, statements of witnesses as well as accused or any person who seems involved in the crime statements are recorded. 162, their evidentiary value under is evidential values only for contradictory, not for corroboration. Under 145 Indian Evidence Act, 145 1, 145 2, and their corroboration and contradictory value is evaluated. And under 158 9, 60, their corroborative evidence are gathered. Under 163, no inducement, force, influence is exerted by the police. 164, confession or statement before the magistrate. Under 164, if the case is of rape, then the police get prosecutrix statement registered under 161, 164 1, 165 search, 166 search, letter of request when evidence is needed from abroad or from abroad to the court in India, through letter of request. 167, the investigation is to be completed under 60 days. Crime open term of punishment is less than 10 years is if above than 90 days. In NDPS Act under special courts it is 180 days. 168, report is forwarded through senior officer. 169, when evidence are deficient, police may furnish the bond from the accused person on sureties or not. And under 170, forward the accused if before magistrate if the evidence are sufficient. And 171, the bond from the person accompanying the accused, furnished bond from them also. 172, police diary, day-to-day transactions are entered. And 173, to submission of charge sheet to the magistrate. Suppose charge sheet is not submitted within time, then police follow another method under 473 under limitation period and demand under